So for the next 2 sessions, we are going to have a presentation on professional conduct and ethics, followed by public interest and academia. To speak on professional conduct and ethics is a woman who needs no introduction. I'm sure you know who I'm talking about. So I'll say no more. Let's welcome to the podium Madam Victoria Barth.
Thank you. Good afternoon. For those of you who sat in my class, I'm sure you are being your brother's keeper. The devil is not blowing on your eyes. Well, this time the devil is real. He's in the real world with you. And when I ask you to be your brother's keeper, it's not to keep them awake, but it's to keep them alert and alive to the dangers of professional misconduct or the risk of it. So when I saw that I was supposed to talk to you about professional conduct and ethics, I said, oh my, they just came out of the law school. They've just passed the advocacy and legal ethics exam. So I can't come here and refresh your memories about things that you probably know more than I do. Because the LI, the code, the act, they were your bedmates since you are seated here. So what I decided to do instead was to sample the views of some seniors in practice of what they would say to you today if they were talking to you about professional conduct and ethics. And so, pardon me if it sounds one-sided. It may have nothing to do with your cohort, but it is the observations of seniors over the past few years, and especially looking at lawyers freshly minted, if I may address you as such. And they wanted me to remind you, and I believe all the speakers who have come ahead have alluded to reputation, a good name, that all that you have, apart from material things that you can lose at any point in time, is your name. And as Mr. Nkoma said, I believe Madam President was the first to say a good name is worth more than riches. He also said a good reputation tarnished may not be easily salvaged or recovered. And so how do we maintain a good name in this profession? What makes us credible? How do we avoid the pitfalls of unethical behavior, which can mean that somebody is called as a lawyer last year, and in the twinkle of an eye, he's accused of stealing a colleague lawyer's phone and possibly may lose his license to practice for good. And this is not a story that I'm making up. I'm sure you all heard about it on the news. You can't change your bad character overnight, but you can make a decision now that you've actually crossed the Jordan to the other side, that you are going to have a personal value system that aligns with the rules that the law has set and even exceeds it. Reputation comes with integrity, comes with competence, because it's not good enough to just be honest or have integrity. You must be competent. That senior who has a penchant for giving you work the night before or the morning of must know that there's a provision in the rules of conduct and etiquette that says that every lawyer has a duty to give competent representation, to be diligent and to be prepared. Let's assume they don't know, and as Mr. Nkoma said, it's a gift for you to sit up. In that firm, I believe there's a schedule, or at least you know on the Monday, the cases that are coming up in the rest of the week. When you have that kind of senior, and you know that you also have a duty to be competent and to represent a client effectively, it means that even before that brief is assigned to you, if you have the opportunity, you must ask to review it. And as Mr. Nkoma said, perhaps attempt preparing speaking notes for your senior. I'm talking about taking initiative that ensures that you are compliant with the rules of conduct of the profession. It also means that you get the opportunity with tact and wisdom to draw your seniors' attention to the potential of causing you to be in misconduct, because you may very well mislead the court, not deliberately, but due to lack of preparation. And tact and wisdom is one of the things they wanted me to tell you about. So, for example, when you've heard brilliant presentations on disputes and commercial and corporate practice, and you have an opportunity to ask questions, you need to ask yourself, and I'm not going to be popular after this, but I have to say it because my lips are itching. Is that the appropriate time to be drawing the attention of my seniors to the lapses in the program they organized, or do I want to be asking a question that relates to the presentation? Because if this was a scenario between you and your senior in chambers, I doubt that even though you are right, that would have been the appropriate way to do it. The law reveres or highly regards hierarchy. It doesn't mean we don't speak truth to power, but you must be discreet and you must choose your moments wisely. And so they say, when we encounter these newly qualified lawyers in court, we see a lack of respect. And I know for those of you who took the trouble to come to lectures, we dealt with communication on different levels. Professional tone of communication, verbally, in your writing, to your colleague, to clients, to users of the court, to members of the public. But especially when you are dealing with seniors. I'm not saying that when you stand at the bar, because I do recall telling you that at the bar, if I'm standing with my learned senior, Mr. Nkoma, I will not address him as my learned senior. I will say my learned friend. We are equal at that stage. So that we do not indirectly get the judge pandering to seniority instead of the solid arguments or submissions that we each are making. But that does not mean that I will address him with disrespect. So again, they say that you must be encouraged not to be footloose, and I borrow Mr. Nkoma's word. Because one of the things we are noticing is that because the law allows you after pupillage, literally to set up law firms, newly qualified lawyers are banding together and setting themselves up. And they haven't received adequate training in the best traditions and practices of the law. And so you see them ill-prepared, wrongly applying authorities, and it's as if when it is a shouting match, that is when you are doing advocacy. That's not it. They say when we enter the courtrooms, the etiquette of a junior seeing that this is my senior and there are no seats, you don't get up. And I'm saying this may not be your cohort, but I'm telling you this. You're saying, oh, is this ethics? There's also the etiquette aspect of it. You are rather angling your way to call your cases before their cases are called. I'm not saying seniors are angels or they are perfect. But if you are going to observe and learn, it means that you must have the patience. And we've all been there before, where you can sit in a court till 2 p.m., depending on how long the judge intends to sit. In fact, you pray that when you are sent, the lawyer on the other side is a senior. Because if it is you and your classmates, then you know that today you have really come. You are going to be there for a long time. So respect for yourself, respect for your friend, be it he or she senior or junior. Respect for the court, because if you respect the court, you will not put up a certain display. Candor is another thing. You see people priding themselves on how they finesse their way through the truth. And you see, we can always tell. Sometimes when you receive a process and you read it, the first thing you want to do is to look at the name of the chambers. And you say, by their fruits. So the advice is, find proper places to be trained. Be patient to receive the training until you move and attempt to set up on your own, because you also want to drive in flashy cars. Those of you who saw me driving in today, I was sitting in some fine Mercedes. It's not mine. My mother bought the car and said, it's for us. And I'm riding in it, and you see me, and hey, Mrs. Barth has made it. National Vice President, yes. My own is on the way. Soon and very soon. But that's not what it is about. First and foremost, the client's best interest. Fidelity to the profession, bringing dignity and honor to it. Which means you are working hard, you are being truthful, even when the facts are against you. I have to refer to Mr. Nkome again, because we do the same thing and he has alluded to it. That when the case is not good enough, he does what? He attempts settlement. In the last few years or so, I have learned that not all respectable members of the profession are respectable. And why is that? Because I've encountered situations where you can tell that this lawyer knows that we should not be in court, and yet they are filing processes. They know and know and know that this is a bad case, and yet they are contesting it. Where you have an appeal and the counsel for the appellant is seeking to stay the hearing of the appeal, you have to ask yourself, what is happening here? We know. It's my life story. So honesty means passing up some of these things, advising your clients, right? Because you see, in the long run, you may make the money. But before the judges, you are earning a reputation. They may just dismiss that application and mulct you in costs. But every time your name comes up and they are seeing those kinds of applications, you are relegated into a certain category. So Mr. Nkoma stood here and told you about his experience in court today. And he said another lawyer may have been fumbling. Well, I've been there in the Court of Appeal. And Mr. Nkoma, I didn't know the Supreme Court authority that has made an exception for filing a reply in the absence of a provision in the rule. So when we finish, I'm going to ask you for that authority. Unfortunately, in my case, the panel also didn't know about the authority. And so I was not allowed to file the appeal. Well, the point I'm making is that you must also be candid with yourself when you don't know and ask. Because if I had known about this authority, I would have urged it on. That opportunity is gone, but another is coming. So, in as much as we are prepared and we are being truthful to ourselves, where we do not have the competence, especially when you are giving a brief and you know that this is not my area, I cannot handle it, you should not be taking it on. When you rush off and go and set up that law firm and it is you and you alone as a sole practitioner, you don't take on more than you can handle just because work is coming. Sometimes even when you have the expertise, you must refer it elsewhere because what? That is what the client's best interest is. I see you walking up. Is the time up? Very well. I'll round up. You let Mr. Nkoma talk plenty. But I will round up and wait for questions. So, as I said, you know the law, you know the rules. It is the doing, and it comes with discipline. It comes with tenacity. It comes with the determination not to let someone else push you off the course that you are on. If I can stand here today and say that I've been an ethical practitioner, it's because I've stood on the shoulders of others, but I've also learned to find my own voice. Because when you are prepared, not even a judge, Supreme Court or anywhere else, will cower you into doing that which you are not supposed to do. So I'll pause here. Thank you for your attention.